Good afternoon and welcome back to our COBRA two-part training series. Today we will be discussing COBRA timeframes. So thank you again for joining us today. Our host is Michelle Barki, our senior legal counsel, who we have been teaming up quite a lot lately to present some webinars, and we're very glad to be back with you today to present the second part of our COBRA training. So Michelle, without further ado, I'm going to go ahead and turn this over to you today.
Well, thank you, Casey, and welcome to our part 2 of our COBRA series. And as Casey said, we are going to talk about timeframes, but we're going to talk about a whole lot of other things as well. Timeframes certainly would not keep us the whole hour. We're going to talk where we left off last week, where we covered what a qualified beneficiary was and triggering events and some things that were not triggering events. Today, we're going to pick it up with gross misconduct. That is an exception for COBRA, that if you terminate somebody for gross misconduct, you do not have to offer them COBRA. We are going to talk about notices and timeframes. We're going to talk about leave of absences, severance packages, and other notices. And between this two-part series, that should cover 96% of COBRA. And of course, there's always those outliers that always come in. So with that, let's start with gross misconduct. And as I indicated, gross misconduct is an exception to COBRA. If you terminate someone for gross misconduct, you do not have to offer them COBRA. However, before you do that, always consult an attorney. Fines by the DOL and the IRS. Yes, we're going to talk about that too. IRS does have some penalties as well. The excise taxes for failure to offer COBRA. And you may be subject to paying the claims as well to make the qualified beneficiary whole. So before you indicate, hey, it's gross misconduct, I'm not going to offer COBRA, check it out. Now, gross misconduct exception, you have to have a termination of employment for gross misconduct, and that is not a qualifying event. However, in COBRA, there is no set definition as to what gross misconduct is. So therein lies the rub. But what we do know is it does not include poor performance, and it is also an area that is highly litigated. So we've got to be careful. And talk about highly litigated. Let's talk about some cases so that you get the idea of what gross misconduct can be. Well, the first one was Bryant Foods, and this was way at the beginning of COBRA. And the assistant store manager failed to hear repeated warnings from his boss about the cleanliness of the store and the product level. He ignored the temperatures in the dairy products. And finally, they ended up firing him, and they said it was for gross misconduct. And the court actually agreed. Today, it would not rise to the level of gross misconduct. It's a performance issue, but that was one of the first COBRA cases. Even though it came out of the circuit in 2001, it actually dated back to 1989. So again, it is one of those cases that it's out there, but don't rely on it. And then we have MISA versus Unitel Communications, Inc. And this was an employee who worked as a controller, and he was taking information to a new company that he was hoping to get hired at, and that was considered gross misconduct. That was also not considered gross misconduct because they said that he had the right to do that. Now, Lawson versus Senate of the Commonwealth of Pennsylvania, it was a judge, believe it or not, and basically, while he was on the bench, he was also procuring controlled substances through some of the defendants and through some of the subordinates. And of course, the judge was convicted of a felony, and they said that is gross misconduct. And then Lloyd was not gross misconduct, and that's when he, again, a performance issue. Apparently, he was supposed to mix onion powder into ravioli, And he kept on failing to do this. It was not a one-time event. So they terminated and they said, hey, he never paid attention to us, so it's gross misconduct. No, it's a performance issue, not gross misconduct. Now, the case I always rely on when I'm looking at it, because it's a fairly recent case from 1995, and it really does indicate what gross misconduct was. The employer, this was a sales individual. He was out on the road all the time selling. And as part of his job description and in the human resource manual, it kept on saying that you do not, you're not allowed to go out and take clients out for a drinking lunch or to have drinks at lunch and then get into the company car. Well, he did just that. He was drinking at lunch with a client, got into the company car, had a very, very bad accident. And the company fired him and said it was gross misconduct. He violated their employer handbooks. He violated his job description. And he committed a crime by driving under the influence. So the sad part of this case was at the time his wife, who was his qualified beneficiary and was also covered under the plan, was 8.5 months pregnant, and the whole pregnancy was not covered. And the court agreed that unfortunately, she was not a qualified beneficiary with independent rights to elect because he was fired for gross misconduct. And then the next one kind of is deceiving, and that's why it's really important to talk to an attorney before you decide that it's gross misconduct. Here they said the employee falsified mileage reports, failed to attend 2 mandatory meetings, and received unsolicited offers of employment from others. Well, if you looked at failure to attend meetings and receiving unsolicited offers of employment, you know, that might be a termination offense and it might be a performance issue, but it's certainly not gross misconduct. But what about this employee falsifying mileage records? And you think, yes, indeed, that is gross misconduct. However, what happened here was when the employer was asked to prove it, they could not. They never had anything documented that he had falsified those mileage records. So again, if you're going to terminate someone for gross misconduct, make sure you have the documentation to support any real serious issues that involve dishonesty. Now we're going to talk about COBRA notices and what they are. First, we're going to do a poll question, Casey.
Absolutely. So we have a couple of polls for you guys today. Let's put the first one up here on the screen. Here we go. I can provide the initial COBRA notice in open enrollment. Is that a yes, a no, or a maybe? While you guys are taking the time to answer the questions for the poll, just also note and be on the lookout for an email from Medcom Benefit Solutions earlier today. If you didn't get it in your inbox, make sure you check your spam filtering services, anything like that. We are doing a follow-up Q&A next week. On the American Rescue Plan Act, so you definitely want to get some information on that. We're going to take all of the questions that were given to us on Tuesday and look at answering those questions for you guys next Thursday at 2 o'clock, and I'm sorry, at 10 a.m. I know we normally do things at 2, but this one is at 10 a.m. on Thursday, and you have that information in the email that was sent out earlier today. All right, so it looks like we've got several people who voted. I'm going to go ahead and close this poll and then share the results. So, Michelle, it looks like 25% of people said yes, 34% said no, but 41% said maybe. What do you say, Michelle?
I say the answer is typically no, you cannot provide at open enrollment. And we'll be giving you the reasons why when we get to the actual notices. So the no's have it, 34%. Okay, so the first notice is the initial notice, also called the general notice. And this is where you provide all the plan, people who enroll in the plan, you give them the initial notice that tells them about some of their expectations. For example, if you get divorced, you have to let us know within 30 days that you are divorced so that that becomes a qualifying event. You get COBRA, but you're no longer covered under the plan. 90 days after open enrollment, you have to do this. Now, why is it that it shouldn't be in the enrollment packet? Is it supposed to go not only to the employee who might be enrolling in the coverage, but also to the spouse, also to all the qualified beneficiaries in the family? So if you have an adult dependent, it would go to them as well. So if you just do it at open enrollment, you don't know whether it's been delivered to the beneficiary. The safe harbor provided by the Department of Labor is if you mail it to the last known address of the individual and you address it to the employee and all the qualified beneficiaries, then that is the safe harbor. And they will assume that it has been delivered to the qualified beneficiaries. But if you give it an open enrollment, there is no safe harbor and you could face some issues. So you always want to provide that initial notice at the time of you want to do it not during open enrollment, but by mail with the qualified beneficiaries listed as well, so that you can actually show that you satisfied that safe harbor by the Department of Labor. The second type of notice is the actual election notice, or also called the qualifying event notice. This is when there's a qualifying event, the employee is no longer entitled to coverage, or a qualified beneficiary may no longer be entitled to coverage. And the employer must then notify the plan administrator. Sometimes the plan administrator is actually the employer, but they have basically 30 days to notify the plan administrator of the qualifying event. If you have a third-party administrator doing this, like Medcom Benefit Solutions is a COBRA administrator, you have 30 days to notify us of the qualifying event. And then we have 14 days to get the notice to the employee and to the qualified beneficiaries. And that is also done via mail. That is also the safe harbor to the last known address. We don't have to prove that they actually received it. The safe harbor is you mail it to the last known address, and that is satisfactory. Now, in the initial notice, it's important because this is the notice that tells an employee and their qualified beneficiaries what they must do in case of an event that may make them lose coverage and then be eligible to do COBRA. So the initial notice requirements, you have to give the employees their rights as well as their obligations. You have to identify the qualified beneficiaries, and you have to let them know what happens to benefits when a qualifying event occurs. What happens if a covered dependents experience a qualified event? For an example, with the spouse, if the spouse gets divorced, and that's a qualifying event, and therefore she has the right to independently elect COBRA. One that often employers forget about is that dependents are covered till the age of 26. And it should be at least to the end of the month of the 26th birthday, because that's an ACA requirement that you don't terminate dependents on the 26th birthday. You have to go to the end of the month under ACA if you're an applicable large employer. And when they lose that benefit because they've reached 26 and they've maxed out, they are entitled to COBRA. So you have to let them know what happens if that covered dependent experiences a qualifying event. Without that initial notice, the employee and the qualified beneficiary might not know that this is a qualifying event that must be reported. You must provide the plan contact information or the COBRA contact information, so if there's any questions or if they do have a qualifying event. Consequences of failing to notify a qualifying event, that's part of the employee's obligation, that they need to know they have that obligation to do so, and if they don't, what is the consequence? Then you have to also let them know the length of coverage periods, payment requirements, the DOL notice of ACA exchange or marketplace. If you choose COBRA over the marketplace, at the end of COBRA, it's not a special enrollment right, so you've got to let them know about the marketplace. And let's be honest, the marketplace may be more affordable, especially if you've lost your job. You must talk about COBRA regulations, and then information on second qualifying events and extensions, and of course the extension if you are disabled. So all that information goes into that initial notice. And again, without this initial notice, qualified beneficiaries, i.e. spouse dependents, may not know they've had a qualifying event that requires them to be terminated from the plan and what they must do. Now, the COBRA election notice, that is when they actually have a triggering event that causes them to lose coverage. And after receiving notice of such a qualifying event, the plan must provide all qualified beneficiaries with an election notice within 14 days. And the election notice describes their right to continue coverage and how to make an election. So if you look at it, you know, there is 44 days, 30 days before that you have to notify the plan administrator, and then the plan administrator has another 14 days. Now, if you are fully insured, carriers follow this pretty closely. So let's say, for an example, you forgot to notify the plan administrator and you did so within 40 days instead of 30 days. And then you come up to the plan administrator and say, can you get the notice out within 4 days? And the plan administrator may say, we'll make an exception, and it's not part of our normal process. Usually it takes us a little bit longer, but we'll rush it through and we'll get it out in 4 days. So the total time frame was 44 days. You think you're good to go. And then the carrier asks, when did you notify the plan administrator? And if you're off of that 30 days, potentially the carrier is going to give you some grief. And the same goes for the reinsurance carriers if you are self-funded. So please, if you are an employer, don't think that you can buy a little bit of additional time by eating into those 14 days. It has backfired on occasion. Now, the COBRA election notice, it has also some content requirements. The name of the plan along with the addresses and telephone numbers of the plan's COBRA administrator. We have to identify the qualifying event. What is the event that caused the coverage to terminate? Identify the qualified beneficiaries by name or by status. An explanation of the qualified beneficiaries' right to elect continuation coverage. They have that independent right to elect. So even if the employee says, I'm not going to elect, his qualified beneficiary may choose to elect. The date the coverage will terminate or has terminated if continuous coverage is not elected, and how to elect the continuation of coverage, where to send the money, when to sign the forms, etc. So a lot of information goes into these notices. We also have what happens if the continuation of coverage isn't elected or waived, what continuation of coverage is available and for how long, how continuation of coverage might terminate early. You know, the premium payments, due dates, grace periods, you have a 30-day grace period to get that information, to get that premium in. A statement of the importance of keeping the plan administrator informed of address changes, even for the qualified beneficiaries, and a statement that the election notice does not fully describe COBRA or the plan, and that more information is available from the plan administrator in the form of the summary plan description. So it's very, very important that the notices contain all this information. And we have another poll question. Casey, take it away.
Thank you, Michelle. Our next poll question is, who can sue under COBRA? The Department of Labor, the qualified beneficiary, the representative of a qualified beneficiary, none of the above, or all of the above? While we're taking a moment to get those answers in, there's something I'd like to address with everyone. It's a question that we've seen come up in the last few days, the last few weeks, especially with the change in a lot of regulations. We have had requests that we send out our presentations ahead of time, that we provide the slide deck ahead of time, and I understand that concern about taking notes and wanting to have all of the information up front. I will explain a little bit of why we don't typically tend to do that, especially with COBRA. there's a lot of information that isn't represented on the slides that we have on the screen. So if we were to send this out ahead of time and by some chance something came up in your schedules and you weren't able to attend, you might not have the full picture. And so by not sending out the information ahead of time, we are in a way trying to protect you and ourselves as well. We definitely want you to have the whole picture, all of the information and the details, and that kind of comes along with not only listening and attending and being a part of the presentation, but then with the slide deck as kind of, you know, a backup source of information. So just wanted to put that out there and appreciate your understanding, and just wanted to explain for those that have reached out about that request in the last few weeks. All right, so it looks like we have a lot of...
add to that, Casey, if you're one of these anal retentive people that really do like to take notes, as Casey indicated at the beginning, we do send the recording as well, so you can always re-listen and take the notes.
Yes, thank you, Michelle. So we had several people vote in the poll, and the results are overwhelming for all of the above. Michelle?
All of the above have it. Thank you, Casey.
There you go, Michelle. Thank you so much.
And let me explain all of the above. I bet you some of you who did not put all of the above thought, you know, does the DOL actually sue? You know, they can charge up to $110 a day if you fail to, you know, follow the COBRA regs, or if the notices are not adequate or they're not put out. But believe it or not, the way COBRA laws is written is that the DOL just can't come out and actually fine you that $110 per day. It has to go to court. DOL has to bring it to the secretary or even one of the administrative law judge or a regular court and say, hey, I want to give this $110, and then it's going to be up to the judge. The judge may decide that maybe $110 is excessive under the circumstances. Each case is reviewed individually, so that the DOL just does not get to come in, do an audit on you, find your COBRA is defective, and then say, okay, this is the amount of your penalty. They have to take it to court. There is mandatory reporting to the IRS. If you fail to give the notices on time, you have to report it to the IRS, and the IRS can charge you an excise tax. And the excise tax typically matches what the DOL can find you, maybe a little bit more, a little bit less, depending. But the IRS also has the right to say, show me what you did. And if you made a good faith effort, just like it is with everything that we do with the IRS, if it's reasonable, the IRS may waive it. But very few people know that there is actually mandatory reporting to the IRS. And as I always say, don't mess with the IRS. They'll come find you sooner or later if they find out that you did fail to provide those notices. Now, under the COBRA laws, they also gave employees and beneficiaries the right also to sue, so that they don't even have to have the DOL's consent. They can independently sue under COBRA. They can sue for that $110 a day, believe it or not. And they can also sue for any medical claims to be made whole. So for an example, if they did not get the COBRA notice and then they experienced $100,000 worth of medical claims, they're not covered under COBRA, they can still get that $100,000 potentially reimbursed by the employer. The second part of that is if you are a private entity, a private company, they can also go after court costs, attorney's fees, and potentially punitive damages. If you are a public employee under the Public Health Service Act, they cannot do that. They can only sue for the claims and for the $110. Class action suits are being filed in Florida and in Texas, so beware. And I'm sure they are in other states as well, but we do have a lot being filed in Florida. So we have to be very, very careful to make sure our election notices are appropriate and that they go out. Now, COBRA leave of absence is important as well. Under the family medical leave, COBRA must be followed when the qualified beneficiary was on coverage the day before they were on FMLA, and then they do not return to work at the end of FMLA, and they would lose their coverage if it was not for COBRA. So again, with FMLA, if they were covered the day before going out on FMLA, they don't return from FMLA. The triggering event is the date they did not come back from FMLA, and they are entitled to COBRA. COBRA must be offered even if the employee doesn't pay his premiums during FMLA. You know, we always talk about termination for failure to provide, to pay premiums, or maybe even the employee said during a period of time for FMLA, I don't want to be covered because I don't want to pay my premiums. Always see what the law says. The law says if they were covered the day before FMLA, they are covered for COBRA. And when they don't return, that is the triggering event. Now, again, premiums covered during FMLA, I always like to say that coverage does not terminate at that stage of the game. It's kind of in a suspension, so that because they had coverage prior and they didn't return, it is a COBRA qualifying event. Now, non-FMLA leave is a whole different story. Potentially the start of the leave may be a qualifying event. It may be at the end of the leave, or it may be anywhere else in between. But here's what I want to warn you about. Make sure any non-FMLA is clear in your plan documents. So for an example, you say that we're going to be giving employees a sabbatical potentially, you know, they're teachers or they, you know, you're in a private school, and every 5 years they get 4 months of a sabbatical where they can go out and do research and not work. Make sure it's always clear in your plan docs, and make sure that the insurance carriers understand that, so that that's the business that they quoted on. And if you're fully insured, make sure the reinsurance carriers quoted you on that. If you just go ad hoc and somebody comes in and wants a leave of absence and you say, well, sure, that's no problem, and the carriers don't know about it, or it wasn't what the reinsurance expected, they could definitely give you some problems down the road. So whenever you talk about a non-FMLA leave, or always make sure that you've got your ducks in a row and that documents are clear to that effect, and follow the plan documents. And again, it's exactly some of the severance packages. The issues are the triggering event did not cause the loss of the coverage. Is the arrangement in the plan documents? Are your fiduciary obligations satisfied? You have the absolute obligation to administrate the plan in accordance with the plan doc and in accordance in the best interest of all the participants. And now you've given somebody leave of absence that's not in your plan doc, that's not in your human resource policies. The carrier comes back and says, we're going to deny that $100,000 claim. The employee then comes to you and say, yeah, but you told me it would be covered. So now you could be on the hook for that. So always make sure that you've got your ducks lined up in a row as far as these issues are concerned. One of the things that you can always do is you can always, instead of using if you don't have it in your plan docs or in your handbooks for everyone, you know, you can always say, okay, we'll terminate you. It's a triggering event. COBRA would be eligible. Doesn't matter who pays COBRA. You might say, we'll pay part of the COBRA. You pay what you would normally pay. You can make all sorts of arrangements that way, and it would still be covered. So always make sure that you take a really good look before you do anything ad hoc that might get you in trouble later, and make sure that these arrangements are clear and in writing. So there's a couple of other types of notices that we want to talk about. One is the unavailability of continuation of coverage notice, and it must be received within 14 days after the request is received. And maybe they don't get the continuation of coverage. We see this quite often when we have that Medicare extension for 29 months, between the 18th and the 29th months. And sometimes they didn't receive the disability on time, or it didn't follow what the law actually says, and we have to say, well, no, sorry, you don't get this continuation. Or maybe they've notified us way too late in order to be able to get the continuation. So at that stage of the game, it's almost like a declination letter that no, there's no coverage here. And sometimes there is a termination of coverage notice where there is no specific time, but it must be given as soon as practicable. Whenever you're talking about any kind of notice, even if there's no time frame in there, give it as soon as reasonable and as soon as practicable. So some helpful information as well. Sometimes somebody is on COBRA and they don't give us the full COBRA premium. So short payment notices are required when there is insignificant shortfalls. When premium is either $10 or $50, 10% or $50 short, then you've got to give them notice that for this insignificant shortfall. Do not send premium reminder letters. They have a 30-day grace period. And so you send them out a reminder notice 10 days before the end of the grace period and say, don't forget, you sent us your COBRA premium. This can actually extend the grace period and you're going to be in a world of hurt, and we could go on that way forever. So never send out a reminder letter. They've got the notices. They know when they're supposed to pay. They know the grace period is 30 days. They can always phone and we can always say 30 days, but do not send out a premium reminder letter. DOL requirements, as we said, this is where the safe harbor is. Mail notices first class with a post office certificate of mailing or properly documenting the mailing with records, somewhere that you can actually trace it back to the individual. And that way, that is the safe harbor. If the employee says, or the qualified beneficiary says they didn't get it, as long as you mailed it to the last known address and you can show that you did, you're good to go. Notice is considered furnished at that time. And hand delivery or the electronic delivery are not typically recommended, as we talked about with the initial notice, because it is not the safe harbor that the Department of Labor gave us. Potentially down the road, they'll say that it's okay, but now it's not the safe harbor. First class mail is. And most plans terminate the qualified beneficiary's coverage at the time of the qualifying event. So we always want to make sure that we have all those notices out. So with that, that brings us to the end of our COBRA training. We have now completed part 1 and 2, and that covers about 95% of COBRA. And at this stage of the game, do we have any questions, Casey?
Michelle, thank you so much. Yes, we do have some questions that have come in at this time. Go ahead and take a moment to think about any other questions that you guys may have. And now let's go ahead and get to the questions that we have here in the questions panel. So we're going to go back, Michelle, to that first poll question that we had about the notices for during open enrollment. If the eligibility coincides with open enrollment, then shouldn't the answer be maybe?
Again, the biggest issue is that it is those qualified beneficiaries, the spouse and the dependents. If you give it to the employee, how do you know that they shared it with the spouse and the dependents? And the safe harbor for that typically is first class mailing with everyone included. That's the safe harbor that the Department of Labor gave us.
Got it. Thank you, Michelle. If an employee is not on our benefits, but are eligible to be on our benefits and they are terminated or they resign, should they receive COBRA?
No, if they only get COBRA if they are on benefits the day before the qualifying event.
Got it. Thank you so much. If an ex-employee elects COBRA and then gets married, can they add the spouse on the COBRA plan? Or what if they have a baby? Can they add the baby?
Yes, under special enrollment rights, they can do so.
Got it. Thank you. Michelle, do you mind to spend just a little bit more time reviewing the mandatory reporting to the IRS?
Yes, there is an actual form that is completed. I forget the form number. And for that last question, I want to check whether you can add your spouse or not. I know you can add the baby, but I don't know about the spouse. So let me check with that before I give a definitive answer on the spouse. Sometimes I get a little hazy on a couple of the details, I know you can, the baby. Yes, there's a specific form that you file with the IRS indicating that you failed to provide a COBRA notice, and at that stage of the game, the IRS will come back and you give all the reasons on this form, and the IRS can come back with an excise tax. But it is a mandatory requirement, and it's a mandatory form. And Casey, along with this presentation, I will give the form number that they have to complete and a copy of it.
Excellent. Thank you, Michelle. I appreciate that. The next question, does the employer have to provide a notice when the 18 months expires? Or any, like the subsequent months?
I do not believe so, but I will check that out. I do not believe that you have to send another termination notice, but I will check that out with my COBRA department.
Okay, thank you. With regard to the qualifying event notice distribution requirements, the qualified beneficiaries must notify the plan administrator, the employer, within 30 days of the qualifying event. Must the plan admin or employer then notify the TPA, such as Medcom, within 30 days? Then Medcom has 14 days to send the proper QE notice. Is this how this works?
Yes.
Excellent. So qualified beneficiary notifies plan administrator within 30 days of QE. Plan administrator notifies TPA within 30 days, and the TPA has 14 days to send proper QE notice. Great.
Yes.
All right. We allow employees to pay health plan premiums directly to the employer during and after FMLA until they return to work. Do we still need to offer COBRA after FMLA?
Again, it all depends what's in your plan document. This is a very, very highly litigated area. And I will tell you that carriers and reinsurance carriers will follow that 12-week very carefully. And at the end of the 12 weeks, we've seen this a lot with the reinsurance carriers. At the end of the 12 weeks, they will come back and basically say, hey, we noticed that you were on FMLA, you're no longer on FMLA, you did not return to work. We have nothing in the plan documents that say that the employer is extending the benefits beyond FMLA. So therefore, we believe that it should be terminated at FMLA. It was not, and therefore we're terminating it at that point for termination. And Mr. Employer, now maybe you are going to be liable to pay all those claims because nothing was followed appropriately. So I always want to make sure that the plan documents that you provide the carriers and the reinsurance carriers match up with your actual practice. Exactly. And that can be in your handbook, and that's provided to the carriers, like this is what we do, and see if the carriers or the reinsurance carriers accept it. But there's a lot of litigation on that side.
Right, and kind of staying with the same theme of FMLA, when that employee doesn't return from FMLA, does that employee and his or her spouse get a COBRA notice? Yes,
if they don't return from FMLA, that's a termination, and they should be getting the COBRA notice. And for those that say they continue it and maybe it's not in your plan document and nobody's agreed, one of the things that you can do is put them on COBRA and pay the COBRA premiums.
Thank you. Another question here, do you mind to clarify the difference between Medicare eligible and Medicare entitled, and how either impacts an individual currently an active COBRA continuant?
Excellent question, and we covered it last week, but let me go through this once again. Medicare eligible is that you have met all the requirements for Medicare. For an example, you have worked your 40 quarters and you have contributed to Medicare, and you are now 65 years old. You are eligible to get Medicare. However, for some reason, maybe you do not want to take Medicare, you are still Medicare eligible, but you haven't taken it. Once you take Medicare, you are now Medicare entitled. So eligible is you've met all the qualifications, but you haven't taken Medicare. Entitled means that you've actually taken Medicare. Now, here's the crux of Medicare and COBRA. If you have someone who is 65 years old and they are an ongoing employee, they haven't quit their job, they're still working, they haven't retired, we have the Medicare primary and secondary rules in effect. You cannot terminate their coverage and say, we're terminating your coverage at 65 because you're eligible for Medicare, and therefore we're going to terminate. When you're still working, your health plan is primary and Medicare is secondary, except for a few weird situations. So Medicare takes a dim view of that, and there are high penalties if you encourage somebody to go on to Medicare and to drop your plan. But let's say there is absolutely no encouragement on the employer part, but the 65-year-old employee figures it out and the cost out, and he says, okay, I'm going to take Medicare, but now I'm going to drop voluntarily my employee plan. My employer plan, because I've got Medicare, I no longer need my employer plan. And he has a 62-year-old spouse who is not eligible for Medicare at this point. So if you're not eligible, you're not entitled, because you can't take what you're not entitled to. You can't take what you're not eligible for. So the spouse then says, okay, so he terminated coverage, I'm a qualified beneficiary, I am going to go on to COBRA. And the answer is no, you're not a qualified beneficiary. The plan did not terminate the individual at age 65. The plan would have allowed him to continue coverage. It was a voluntary termination. Therefore, with this voluntary termination of coverage, there is no triggering event, and therefore the spouse is not entitled to COBRA. And quite often we see these cases where the spouse has to go for a little bit before they get coverage elsewhere, or they have to go to the individual marketplace.
Thank you, Michelle. And there's also a bit of a follow-up question about that, and I believe you covered everything all in one answer there, so thank you so much. If an employer offers to pay COBRA for some period of time, like severance, when this period ends, this may not be considered a qualifying event for HIPAA, right?
A qualifying event for HIPAA.
Yeah, I'm a little confused about that as well.
Yeah, I'm not, I mean, it's not it's, if the employee pays the premium for a bit of time, and then at the end, after they pay the COBRA, and then they, the employee terminates the COBRA, it would not be a qualifying event to get them into the marketplace for sure. And I guess what they're talking about is it a special enrollment right afterwards.
Yes.
And if the employee comes back, if the employee comes back to work and is still a full-time employee, because don't forget, under the ACA, if you're an applicable large employer, you terminate employment, then you come back to work within 13 weeks. You can do a rehire, and then they would automatically be entitled to benefits. So as long as, if you're an applicable large employer, not more than an additional 13 weeks, you can always bring them back to work as a rehired employee. So there's things that you can play around with that. So I hope that answers the question. That's the best I can answer, not knowing a lot more scenario. But if that individual wants to write us a scenario, we can work out the scenario and figure out what to do.
Great. Right, we have one last question here that's come in. If an employee out on FMLA notifies the employer of their resignation as of the last day of FMLA eligibility, when should their termination be effective? And therefore, when is the COBRA notice due? 14 days from notice or 14 days from termination?
14, if they notify the plan, read that question again, Casey.
Sure. If the employee out on FMLA notifies the employer of their resignation as of the last day of FMLA eligibility, when should their termination be effective, and when is the COBRA notice due?
Termination would be effective the date that they terminate after they do not come back from FMLA. Then 30 days and 14 days would apply.
Okay. All right, we have,
here's
sorry,
here's one other thing for you with the FMLA. Say your employee goes out on FMLA and you've made all these arrangements prior to them to go out on FMLA that you are going, because you can make any arrangements you want with your employees as to how their employee cost is going to be met. You can't force them to pay in advance, but you can make arrangements, and whatever you two of you agree upon is basically fine. So you tell the employee, okay, I'm going to pay all your share of the premiums while you're off an FMLA. And then when you come back from FMLA, you can pay me $50 a pay period in addition to what you're already paying in order to make up the premiums for the payment that you were away from, that you were away. That is fine. But if the employee goes off on FMLA and then does not come back, and it's due to the same reason that they were on FMLA, so potentially they never got better from an illness, and they could no longer work. If they do not come back from FMLA and it's for the same reason, you cannot recollect that money.
got it. Thank you so much, Michelle. And thank you to everyone for attending today.